If you or someone you know is planning to travel outside the United States for visa stamping, whether for an H-1B renewal, H-4, F-1, or any other category, I need you to stop what you're doing right now and watch this entire video before you book that flight. Because as of January 2026, the U.S. government has put into effect a series of overlapping policy changes that are creating serious complications for travelers at consulates around the world. And the dangerous part is that most people have no idea these changes are already active. Some people are booking appointments, flying abroad, going to their interview, and coming back with a 221G administrative processing hold, a visa denial, or worse, they can't get an appointment at all for the next 6 to 8 months. This is not a situation where you can afford to wait and see. The decisions you make in the next few weeks could determine whether you stay in valid immigration status or not. Stay with me. This is going to be one of the most important immigration updates I've covered this year. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. My goal is always the same: give you accurate, policy-based information so you can make informed decisions about your immigration future. Before we go any further, I do need to state clearly, I am not your attorney, and this content is for educational and informational purposes only. Always consult with a licensed immigration attorney about your specific case. Every situation is different, and nothing I say here constitutes legal advice. Now, let's get into it. There are 4 major policy developments that have come together in early 2026, and when you understand how they interact with each other, you'll understand exactly why I'm saying, do not travel yet without a clear plan. The first, and the most significant, is Presidential Proclamation 10998. This proclamation went into effect on January 1st, 2026, and it targets citizens from 39 specific countries. Under this proclamation, the U.S. government has suspended or severely restricted visa issuance for nationals of those countries. The official source is the U.S. Department of State's page on suspension of visa issuance, and I'll reference it throughout this video. Now, what exactly does this proclamation do? At its core, it directs consular officers to either deny visas outright or place applications on indefinite hold, what the State Department calls a visa issuance pause, for nationals of those 39 countries. These are countries that have been designated as either unable or unwilling to share adequate security vetting information with the United States government. This falls under the broad authority of Section 212F of the Immigration and Nationality Act, the INA, which gives the President the power to restrict or suspend entry of any class of aliens when it is deemed detrimental to the national interest. We saw this same authority used in the travel ban cases several years ago, and the Supreme Court upheld it. That legal precedent matters here because it means this proclamation has already survived the legal scrutiny that previous orders did not. Now, which 39 countries are affected? The official list is available on the State Department's website, and I strongly encourage you to go there directly. The list includes countries across Africa, the Middle East, parts of South Asia, and Central Asia. If your country of citizenship or birth, note I said birth, not just current residence, is on that list, your visa processing has been impacted regardless of where you currently live or what visa category you're applying for. But here's where this becomes critical. Many people make the mistake of thinking this only applies to people currently living in those countries. It does not. If you were born in a country on that list, even if you've lived in the United States for 10 years, even if you have a valid H-1B petition approved, even if your employer has been sponsoring your green card, you may face complications when you go abroad for visa stamping. Consular officers are conducting nationality reviews, and your passport or your country of birth can trigger enhanced vetting protocols. This is what many applicants are misunderstanding right now. The second major development is the expansion of social media vetting requirements and this one directly targets H-1B and H-4 visa applicants. In late December 2025, updated guidance was pushed out by U.S. embassies and consulates globally, including the high-traffic consulates in India, Pakistan, and the Philippines, requiring that applicants now provide their social media handles as part of the visa stamping process. This isn't entirely new as a concept. The State Department has collected social media information on DS-160 forms for some time, but the enforcement and the depth of the review have been dramatically expanded. What this means in practice is that consular officers are now actively reviewing your public social media presence before and during your interview. Your posts, your comments, your likes, your associations, all of it is being reviewed as part of the vetting process. The official source for this is the U.S. Embassy and Consulate screening and vetting update pages. And here is the key concern. If your social media contains any content that could be interpreted as anti-government sentiment, association with certain political movements, content related to certain foreign governments, or even ambiguous posts that an algorithm flags, you could receive a Form 221G administrative processing notice. That means your passport stays at the consulate, your visa is not issued, and you are stuck waiting, sometimes for weeks, sometimes for months, with no guaranteed outcome. There's one detail most people are missing on this point. The 221G hold is not a denial, but it is not an approval either. It is a legal limbo. And during that time, if you are an H-1B worker, your employer is still waiting for you. Your project is still moving forward. Your bills are still due, and you have zero control over the timeline. This is why social media hygiene before travel is no longer optional. It is a critical part of your visa stamping preparation. I'll give you specific steps on what to do about this in just a few minutes. Now let's talk about the third development, and this one is going to affect a huge number of people who thought they had a simple, straightforward visa stamping process ahead of them. The interview waiver program, what most people know as the Dropbox option, has been significantly restricted in 2026. For many years, eligible applicants, typically those renewing the same visa category within 48 months, could simply drop off their documents at a designated facility, skip the in-person interview, and receive their stamped visa by mail. It was efficient, it was low stress, and for many H-1B renewal applicants, it was the standard path. That path has now been severely narrowed. U.S. embassies in India, Pakistan, and many other countries have issued consular announcements confirming that in-person interviews are now required for a significantly expanded set of visa categories. This includes many H-1B renewals, H-4 applicants, and L-1 applicants who previously would have qualified for Dropbox processing. The specific criteria vary by consulate, and the rules are being updated frequently, so you must check your specific consulate's official website before making any travel plans. Here's the practical impact. Appointment availability at high-demand consulates, specifically in India, where demand is enormous, has dropped dramatically. Current wait times for visa interview appointments at consulates like Chennai, Mumbai, Hyderabad, and New Delhi are running 6 to 8 months in many categories. 6 to 8 months. That means if you are an H-1B worker whose visa stamp expired and you need to travel abroad for any reason, a family emergency, a personal obligation, anything, and you need to get your visa re-stamped before re-entry, you could be looking at being outside the United States for the better part of a year just waiting for an appointment. That is not a small inconvenience. For many families, that is a life-altering disruption. This could affect you even if you are not in a restricted visa category. The fourth development is one that primarily affects those on the path to a green card, and it is very recent. On January 21st, 2026, the Department of State announced a pause on immigrant visa processing for nationals of approximately 75 countries. This pause is connected to expanded public charge rules and enhanced vetting standards under the current administration's policy framework. An immigrant visa is the final step for many people who have waited years, sometimes decades, in the employment-based green card queue. The I-130 petition for family-based cases, the DS-260 immigrant visa application, these processes have been paused for nationals of 75 countries. This does not automatically affect I-485 adjustment of status filings for people already inside the United States, but it does affect anyone pursuing consular processing abroad. If you are outside the United States and you were expecting a National Visa Center interview this spring or summer, you need to contact your attorney immediately to understand the current status of your case. Let me take a moment to put a human face on everything I've just explained, because these numbers and policies represent real people in real situations. Think about someone like Priya. She's a software engineer from India, been in the United States for 9 years on H-1B status. Her husband Arjun is on an H-4. Their daughter was born here. Priya's company has been sponsoring her green card through the employment-based second preference category, and they've been waiting in the queue for several years. Her visa stamp expired last year. She had been cautious about traveling, but now her mother in India is unwell, and she needs to go. She books a trip, assumes she'll use the Dropbox process like she did in 2019, checks the State Department website, but misses the recent consular updates. She arrives in India and finds out in-person interviews are required. The earliest appointment she can get is 7 months away. She's stuck. She's separated from her daughter. Her employer is managing without her. Her green card process continues on paper, but her life is on hold. This scenario is not hypothetical anymore. Versions of this story are playing out right now, and most of the time, it was preventable with the right preparation. So what do? Here is your concrete action plan. Step 1. Before you do anything else, check whether your country of citizenship or birth is on the Presidential Proclamation 10998 list. Go to the official U.S. Department of State website, find the suspension of visa issuance page, and review the list carefully. If your country is listed, consult an immigration attorney before making any travel plans. This is non-negotiable. Step 2. Audit your social media immediately. Go through your accounts, every platform you listed on your DS-160, and review your posts, comments, and associations with fresh eyes. Think about how a consular officer viewing your profile for the first time might interpret what they see. Posts that are inflammatory, politically sensitive, or that involve associations with governments or organizations currently flagged in U.S. foreign policy can trigger administrative processing. Clean up what you can and make sure your profiles are either public and presentable or appropriately private. And yes, set them to public before your interview, because a suddenly private account after years of public posting can itself raise flags. Step 3. Contact your specific consulate directly to confirm whether you qualify for interview waiver or whether an in-person interview is required. Do not assume your 2022 or 2023 experience applies today. Consular policies are being updated regularly, and the only reliable source is the official website of the specific U.S. embassy or consulate in the country where you plan to stamp. Step 4. Check appointment availability now, even if you are not planning to travel immediately. Understanding the current wait times at your target consulate will help you build realistic timelines for any upcoming travel needs. If you see a 6-month wait and you have a family obligation coming up in 3 months, you need to know that now, not 2 weeks before your flight. Step 5. Consult a licensed immigration attorney before you travel. This is especially true if your case has any complexity: retrogression waiting periods, any prior visa violations, any 221G history, any criminal history, any significant gaps in status. An attorney can review your specific situation and help you assess the risk of travel before you commit to it. Now let me give you the broader picture, because understanding what comes next helps you understand whether these policies are likely to stay, evolve, or change. Presidential Proclamation 10998 is an executive action. It does not require congressional approval and it does not go through the standard regulatory notice and comment process under the Administrative Procedure Act. The President has broad authority under Section 212F of the INA to restrict entry, and as I mentioned, the Supreme Court has upheld that authority in prior administrations. This means that changes to this proclamation, if any, will come from the executive branch, not from Congress. They could happen quickly, or they could be in place for the duration of the current administration. Litigation is possible and is likely already being organized, but given the Supreme Court's prior rulings, a successful court challenge faces significant headwinds. The social media vetting expansion and the interview waiver restrictions are similarly executive branch and State Department actions. They are implemented through consular policy guidance, not through statute. That means they can be changed administratively, but it also means they can be expanded further without congressional action. However, this protection may not be permanent, and more importantly, these restrictions may deepen before they ease. The immigrant visa pause for 75 countries is the area where the most legal uncertainty exists. Several advocacy organizations have already indicated they are exploring litigation around the public charge standards being applied in this context. Whether those legal challenges succeed, and on what timeline, is genuinely unclear. Realistically, anyone expecting immigrant visa processing through consular channels should plan for delays of at least several months and potentially longer. I want to be clear about something before I close. I don't share this information to create fear. I share it because the people watching this channel deserve to know the real landscape. Immigration status is not just a legal status. It is the foundation on which families are built. It is the stability that allows you to plan for your children's future. It is the ability to work, to contribute, to build a life in this country that you have invested years of your life into. When policies change this fast, and when the consequences of a misstep are this serious, a 221G hold, a visa denial, months abroad, a disrupted green card timeline, you deserve to have accurate, calm, fact-based analysis. Not rumors, not panic, just the truth, clearly explained, so you can take the right steps. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If this video helped you understand something important about your situation, please give it a like. It genuinely helps this kind of factual immigration coverage reach more people who need it. Drop a comment below telling me your visa category and where you are in your immigration journey. And if you know someone who is planning to travel abroad for visa stamping right now, please share this video with them directly. It could make a real difference. Thank you for being here. Stay informed, stay prepared, and I will see you in the next one.